Conservative justices on the U.S. Supreme Court on Monday sounded highly skeptical toward the legality of race-conscious college admissions policies. The court heard oral arguments in two cases, one involving Harvard University and the other the University of North Carolina. The results could imperil affirmative action programs used to boost enrollment for Black and Hispanic students. Here's conservative Justice Samuel Alito.
College admissions are a zero-sum game, and if you give a plus to a person who is falls within the category of underrepresented minority, but not to somebody else, you are disadvantaging the latter student.
The cases were brought by plaintiffs who argued that UNC discriminates against white and Asian American applicants, and Harvard discriminates against Asian American applicants. An attorney for the challengers demanded schools adopt what he called race-neutral admissions.
This court has always said that racial classifications are necessarily invidious, and certainly it is possible that an applicant, for example, could write something in which race provides a context for their experience, but just considering race and race alone is not consistent with the Constitution.
Many institutions of higher education place a premium on achieving a diverse student population, not simply to remedy racial inequality and exclusion in American life, but to bring a range of perspectives onto campuses. But that didn't seem to move conservative Justice Clarence Thomas.
I've heard the word diversity quite a few times, and I don't have a clue what it means.
While the court's 6-3 conservative majority made clear its sympathy toward the challengers, the liberal justices defended a limited consideration of race in admissions as one factor among many.
How is race being used in this process? You keep saying we object to the use of race standing alone.
Here's Associate Justice Ketanji Brown Jackson, the first Black woman to serve on the court.
But as I read the record and understand their process, it's never standing alone. That it's in the context of all of the other factors. There are 40 factors about all sorts of things that the admissions office is looking at, and you haven't demonstrated or shown one situation in which all they look at is race.
The cases argued Monday give the court an opportunity to overturn its prior rulings, including one as recent as 2016, allowing race-conscious admissions policies at colleges and universities. Rulings are due by the end of June.